Okay. Hello, everyone, and welcome to Steps Towards Fair and Lawful Termination. This is going to be a joint CPD with Melbourne HR and 44 Degrees. Melbourne HR is a HR company, and we're a law firm, and we thought there were a lot of things that are overlapping, and we thought this could help us out. So I'll kick this off. So today, the presentation today is meant to be a bit dynamic. So we're going to look at some scenarios and talk towards those scenarios. If you have any specific questions, please feel free to message us. Otherwise, at the end of this presentation, there'll be some time for questioning and you can answer all your questions if it has not been covered already. So one of the partners of our firm at 44 Degrees is Nicola. Nicola Drakeford has been working in the private sector for many years before joining 44 Degrees, and she was working at departments of Treasury and Finance with Victorian government. Throughout this time, she has been practicing in employment law and has been representing both employees and employers. So her expertise is really helpful in this scenario.
And your second speaker today will be David Simpson from Melbourne HR. Melbourne HR was founded in 2014 based on a belief that SMEs deserve best practice HR delivered efficiently and cost effectively. And just FYI, David has COVID today, so we're very grateful he's here, but he's not feeling super well.
And that is why he is not here with the amazing law books in the background making him look good. Very sad, David.
Very sad. Very sad. All right, so I'll be kicking off today. So I think what's really important is understanding some of the preliminary steps when you're looking at termination. Termination really is almost the end point of a pipeline of decisions and processes that you put in place. And so due process is a really key aspect of any termination process. Running an individual through a fair and reasonable performance management system, that's really key in ensuring that you're hitting those what are by convention called the 3 strikes. These are your sort of 3 formal warnings that you set out. That needs to be in writing. It needs to be there needs to be some evidentiary requirements with those formal warnings. In some cases, that's quite easy. Maybe it could be punctuality. But in the case of qualitative performance, you need to make sure that you have those clear examples of where qualitatively they haven't achieved what you want. Other than that, I think what's clear is that this process can be an emotional one for the employee. Ensure that as an employee you don't get dragged through to that process. You need to maintain a level head at all times. And then I think also as you're going through each one of those formal warnings, you need to have very clear understanding of what you're looking for in terms of change. If you don't get that change, then you can tick off each one of those formal warnings until you get to the last and through a termination act in of itself. Sure, I think these 3 points on the screen, bullying, harassment, redundancy, and micromanaging, they come up quite a lot when we talk about termination. All for sort of different reasons. The bullying harassment comes from employees in a circumstance where they're sort of really looking, they either might find the process quite confronting or they're looking for a way to exit that process and effectively retain their job. A company has a right to performance manage your staff. As long as that feedback is constructive and you've ensured that the feedback you're giving them is based on examples or objective evidence, it will not be construed as bullying. Now, again, it needs to be reasonable, it needs to be constructive, but at the end of the day, even if they're feeling stressed and anxious about it, that doesn't constitute bullying and harassment. Redundancy comes up quite a bit. A lot of companies talk about taking a redundancy process in lieu of a termination. The reason they do it is there's a belief out there that redundancy is easier. The issue with redundancy is it absolutely has to be a genuine redundancy. They talk that phrase used quite a lot, a genuine redundancy. And a redundancy is when you get rid of the position or role, not the individual. So when you do that, you're stipulating that the company doesn't need that particular role or position within its organization anymore, and therefore you're removing it entirely. You can't then replace that position with another that's 100 or 90% the same. And in fact, any high percentage will be looked at. Will be looked at with suspicion. And also, if it has a high percentage, there are requirements that if you create new roles off the back of making others redundant, if the person you made redundant could fulfill that role, then generally speaking, you need to offer it to that particular employee. When it comes to, so the short of it is the redundancy is kind of is definitely not the path you want to take if it's performance based. There are a lot of hurdles in that, a lot of errors that can be made, and also generally speaking, most positions in a company are required. So you'll definitely find yourself with issue. In terms of micromanaging, this is an interesting one. So there's two ways to look at this. One is that micromanaging can be found to be bullying or harassment in the workplace. So that is definitely in the sort of more extreme examples, but it can be found to be bullying and harassment in the workplace. And that obviously is behavior that as a company you need to stop. And secondly, the other aspect of this is if someone is not very good at their role and you're micromanaging, you're potentially losing out on the ability to performance manage that individual because you're going to be micromanaging every step of their day. So I guess the key here is that micromanagement is considered a very poor form of people leadership and management. So not only should it be avoided because it's definitively not best practice, but in addition to that, micromanagement can really put the company in a position of disadvantage with reference to the employee.
Thanks, David. So I wanted to start talking about where traditionally lawyers get involved, which is once someone decides this person, we need to dismiss them, we need to get rid of them. How do we do that? As David mentioned, all of the steps about reasonable performance management, documentation, making sure there's a valid reason, making sure that you are clear in how they can improve and what they need to do to improve, need to happen before you decide to terminate. When you do terminate, there are generally three ways for an employment to end. The first is what we would consider a normal dismissal. It's when you've been performance managing someone for some time, you've made it clear what they need to improve, you've given them plenty of opportunities to improve it, and they still haven't gotten to that level. The second one is serious misconduct. Now, serious misconduct is not something that should be used lightly or easily. And what it really is about is where someone has engaged in serious misconduct that is a threat to the employment relationship or the employment environment. What you traditionally have is serious misconduct is defined in the Fair Work regulations, and it's willful behaviour that is inconsistent with a continuation of the contract of employment. In reality, and in case law, what you see is things like threats to health and safety at work or of clients, theft, fraud, assault, serious sexual harassment, intoxication at work, and other types of things. Now, the benefit of serious misconduct from an employer side is that you can, once you've established that serious misconduct has occurred, dismiss immediately rather than giving a warning, giving them a chance to improve. But having said that, the steps that most people's enterprise agreements, awards, or even their internal policies provide, so you need to do an investigation to make sure the serious misconduct actually occurred. You need to speak with witnesses, you need to gather evidence to be certain that, if someone threatened someone's health and safety, someone assaulted someone, that it actually happened, and that it had a connection to work. So that's something to be aware of when you're looking at summary dismissal. In some ways, it makes people, especially if they're performance managing someone, if they then engage in serious misconduct, they think, yes, it's all right, I can just get rid of them. But you still have to go through a fair process and, give procedural fairness to make sure that you investigate it properly. The third one, which David's already touched on, is redundancy. As David mentioned, the redundancy is about the position, not the person. And as soon as you find yourself in a situation where you're like, aha, I can make someone redundant and I really don't like this person, so that they're the ones I'm going to make redundant, usually that's when you start being on a slippery slope and you need to get a professional advice to make sure it's legitimate. The next slide. So there are 3 general claims that are the most common types of claims when someone's been dismissed. The first one is unfair dismissals under the Fair Work Act. Now, this is the most commonly known one. Effectively, it's where someone is dismissed and that dismissal is harsh, unjust, or unreasonable. The Fair Work Commission will look at a set of 6 different factors when they are deciding whether something's harsh, unjust, or unreasonable. And they include whether the reason was valid. So for example, if you were performance managing someone because they tied their hair in a ponytail and not a bun, unless there was a very good reason for that, that's unlikely to be a valid reason. The second is whether the employee was notified of the reason for dismissal. The third is whether the employee received any warnings about their conduct and an opportunity to improve. If the employee was accused of doing something, whether they were given the opportunity to respond to that allegation and either disprove it or say that it didn't happen quite as it did. Whether the employee had a support person offered to them. This is something that a lot of people forget, because at the start of performance management, you don't want to start bringing in a support person, or a lot of people don't, because they think that this is a warning sign to the employee that they've already made up their mind and they're going to be dismissed. Once you start thinking about termination, you need to make sure you're getting that support person in. And finally, the Fair Work Commission will consider factors such as the employer's size, the resources they have, whether they have an internal human resources department, whether they're a small business, and whether there are other factors about the business itself, which means that they shouldn't be held too strictly to unfair dismissal regimes. So the second up there is other dismissals prohibited by the Fair Work Act. Now, what that usually means is something we call general protections or adverse action. And what it means is someone is dismissed because they've exercised a workplace right. That workplace right generally tends to fall into 2 categories. The first category is the workplace right not to be discriminated against. So when you're looking at general discrimination law and the Equal Opportunity Act, you're looking at discrimination based on race, gender, sexual orientation, and other types of things, religion. And then the second one is when someone's either proposing to use, has used, is proposing not to use, or does not have a workplace right. So these are things like membership to a union, making a workers' compensation claim, raising a concern about occupational health and safety in the workplace, making a complaint about a manager or a peer who is either engaging in bullying or sexual harassment behaviours. So those kind of issues where someone is doing something which the employer doesn't really like, and then it becomes targeted, as opposed to being about their performance, which is what you usually want to see dismissals for. Now, the final category, and I'm not going to go into too much detail on it, is common law or contractual claims for wrongful dismissal. These are usually at the executive level because the benefits that you can get under the Fair Work Act generally outweigh what you can get in court. There's some exceptions to that, but that's the general position. So the people who sue under contract are people who are not covered by the Fair Work Act, but their contract might say they get a certain amount of notice. Their contract might say they can only be dismissed for A, B, and C reasons, and they were dismissed for something else, or where they haven't been given reasonable notice by their employer. So once you start looking at once people are terminated, these are examples of what might be classified as dismissal versus not classified as dismissal. Now, the key thing to really be aware of is it used to be that demotion was considered dismissal under the Fair Work Act. A few weeks ago, there was a judgment by the full bench of the Fair Work Commission, which said that demotion is not dismissal if it was an option to punish someone for misconduct. Now, that doesn't seem consistent with the Fair Work Act, in my opinion. What they would effectively be doing is creating an amazing opening that whenever someone wanted to dismiss someone, instead of dismissing them and being subject to unfair dismissal laws, they just demote them and hope that they quit. I expect that case is going to be appealed, but it's something to be aware of in the moment that demotion is a hot topic. And if you are looking to demote someone, you need to get professional advice about whether you would be exposing your company to claims by doing that and whether you're allowed to in those circumstances. The other examples up there were just training and the end of a contract of employment. So if you're employed for 6 months and at the end of 6 months, the contract ends and they don't re-employ you, that's not generally dismissal. And similarly, if you hire someone for a traineeship that goes for a year or 3 months, and at the end of that, you don't offer them a full-time job, again, that is not dismissal.
All right, so I'll take you through the case studies for today. So scenario number 1, Don't Tail My Vibe is a medium nursery and flower shop business located in Greensborough, Melbourne. DKMV is dedicated to providing quality, organic, locally grown plants. They pride themselves in being able to cater to all of their clients' flowerly needs. DKMV headquarters consist of 2 levels and employs over 105 staff members. The nursery is located on the ground floor and customers are allowed to freely browse this space and make a purchase. The second level is where the office and administrative staff work. Boris Blayton was employed by DKMV on a full-time basis as a nursery gardener in the winter flowers section of the nursery on the ground floor. Boris was previously working at Jim's Gardening and Bunnings, where he tended to indoor potted plants. The direct line manager for Boris, Miss Petunia Potter, reported that the delphinium flowers under Boris's care were wilting, and if they did not act quickly, they would lose all of the stock. Almost a week later, Petunia reported that she had found 3 boxes of foxgloves in Boris's section of the nursery. Foxgloves are poisonous, and because of this, DKMV do not grow or sell them. When asked why Boris had stocked foxgloves, he stated that a customer had asked for the flowers and offered to pay a lot of money for them as she needed the plant for a university project. Upon checking the DKMV website, Petunia saw that this customer had left a highly positive review where she named Boris specifically and praised him for having provided her with such an amazing specimen. DKMV terminated Boris's employment due to poor performance. Boris claims that he was terminated because he is a foreigner and that Petunia was bullying him. He also claimed that the termination was unjust because his performance was excellent, as demonstrated by the review by the customer.
Yeah, sure. I think I might kick it off with Boris Blayton here. So I think, when you're, obviously we're going to analyze these circumstances, but, whenever you're moving into this space yourself and looking at conducting performance management or conducting termination, there's a whole bunch of considerations you need to really look at. Particularly in this case, we want to look at the award coverage. So, here we want to understand exactly, what are the expectations of a level 2 gardening in the gardening landscape award. Why that's important is because, at the lower levels, there can be significant requirements for supervision for these particular individuals. So you don't want to be sitting there and conducting performance management over Boris Blayton because of was it petunias? Delphiniums.
Petunia.
Petunias? All right, one of the 2. There's some flowers. And then, in fact, what the circumstance is that this particular individual is at a certain award level where there needs to be a question about the supervision that individual was given. In addition to that, obviously, with the awards, there are lots of requirements in terms of warnings, terminations. These can all change from awards to awards. So you need to understand the specifics of each award and whether there's anything within the award that may affect the process that you take, the number of warnings, or even, whether you could terminate them based on the responsibilities that particular level is entailed. So all these things can take an effect. So it's really important that an award really isn't just a pay scale. An award is a lot more than that. And understanding that will allow you or give you insight into the circumstance that you have, and therefore what you can and can't do, or what potentially processes or mods to processes that you may take to ensure a fair and due process. With Boris and specific training around winter flowers, I guess there's a few things, there's a sort of a few things you want to take into account there. You'd have to ask yourself, do the winter flowers need particular training? Is there plant husbandry so vastly different from other flowers? Two, you'd ask yourself prior experience. He worked at Bunnings and Jim's Gardening. So you may take that into account as well. So, when it comes to whether winter flowers are something that is an important detail to explore, that will sort of depend a lot around circumstance and situation. And I guess one of the things I'm really trying to highlight here is that, when you look at these roles and these circumstances, it's not just, oh, well, Boris did something I don't like, and therefore I'm going to go through performance management. You really need to explore the situation, understand where the action is relative to the other elements and variables within the situation. And I think that's really key for everybody at this workshop, making sure you understand that situation and where things relatively sit is so key. And the last one, I think I'm going to hand over to you, Nicola. Public versus private. You think you wanted to talk about that?
Yeah, this is not so much likely to be relevant for Boris himself, but another factor, if you ever are dealing with someone who is in public sphere, whether that's directly the government or quasi-governmental organisations like universities and schools and hospitals, is that there are additional legislative requirements about treatment, fair treatment, equitable treatment, making sure that things are based on the merits. What that really does loop back into is what is required under most awards, which is that you can't just go, well, he's not performing and so out he goes. Are your expectations too high? Has he received the appropriate training? Was he qualified for the job that he was hired for? So talking through some other considerations that you need to talk about. Was Boris aware that the unions actually required more care? Was his experience enough that he should have already been aware of it? Is it a basic understanding that everyone knows in that industry? Or is it something that's specialized? Did anyone give him any verbal feedback? Did anyone give him any warnings? As far as we can see on that scenario for now, is that there weren't any written warnings about the conduct. Now, if Petunia did give written warnings, was it communicated to Boris and did he understand what he needed to do to fix it? You can say to someone, you're not keeping this plant alive, but if you've got as excellent green thumb as me, I can try my absolute best to keep it alive and still kill it. What instructions was he getting? What training was he getting? Is it something that he should have already known based on his experience and qualifications? Or is it something that he needed to be told? And if he did need to be told it, his written warnings needed to specify exactly how he could improve. There's also the concept of scale. How serious is it that these delphiniums might be dying or dead? Is it something that is a significant financial loss to the company, or can we grow some more or order some more interstate for a relatively simple price? I think I've covered most of that. The other factor just to consider is what internal processes does this company have, and did they follow them themselves? Because generally the courts will consider that if you haven't followed your own processes, they're most likely to find that it was not a fair dismissal.
I think just from my end on this one, I think the verbal feedback is a key component here. You know, generally speaking, unless the action is very serious, you know, if it's about generally poor performance rather than something that is very significant and specific, you would always start with verbal feedback. You don't ever jump the gun, so to speak. For instance, you know, with the delphiniums, I realized I mixed up Petunia Potter's name with the flowers. So with the delphiniums, you know, if they just started to wilt a little bit, you wouldn't instantly provide Boris a formal warning, right? Because, you know, they're potentially savable, you know, they've just started to wilt. So that would be some verbal feedback. Like, Boris, hey, the delphiniums, you know, they're not delphiniums, aren't looking very healthy. Can you sort that out today? And so you can provide that feedback there and then. And just jumping on what Nicola was saying around scale, you know, scale is very important. You know, the most extreme example is that, you know, someone takes a pencil home, you're not going to fire them for theft. However, if they go into the stationery store and take 300 pencils, 1,000 pens, 200 rubbers, you know, 50 rulers, then, you know, that constitutes theft. You know, that's, you know, suddenly, you know, you could be looking at dismissal. And then with these delphiniums, you know, are you looking at a large scale delphinium grow for a specific event, or are you looking at just a small section of flowers within a wider nursery? So again, that concept of, you know, how serious is it? Because, you know, delphiniums dying isn't all the same. You know, they are at various scales and various problems.
Just on the pen story, there was a Qantas case where they fired a flight attendant for taking Qantas branded pens off the plane. And that was overturned as unfair dismissal, and that flight attendant was reinstated because they said, come on, it's just pens, just a couple of pens, whatever. This is so into further considerations to start thinking about. So this is talking about Petunia's discovery of the foxgloves in Boris's section. Boris had done it for a customer who had requested it and had been offered a lot of money for it. So the first thing you want to think about is this could be in the serious misconduct category. It could be a slightly criminal category. We don't know enough about foxgloves to say for certain. So did Boris understand company policy about foxgloves or other poisonous plants? Was it a part of his training that we don't provide these? Or was it just, oh, we just so happened to not have any in stock and him thinking that he could provide it? This is where the investigation part of serious misconduct really kicks in, which I was talking about earlier. You need to investigate what's going on in the action. So I don't know enough about plants to know whether foxglove is something that is so poisonous to be something that is a serious criminal matter. If you ever do have an employee where you think that their behaviour may have been criminal, you are more than welcome to just report them to police straight away. Deal with them from an employment perspective, but let the police deal with the criminal aspect. There's also occupational work health and safety issues. Is just having the foxgloves out in the open where anyone could touch them, putting anyone at risk of poisoning? Or do you need to ingest them to make it poisonous? What was the process that he used? Was he planning on pocketing that large amount of money himself from the person, or was he putting it through his employer's business? If he was pocketing himself, it went out to theft. Really, what ultimately comes down to is you need to investigate how, why, the consequences of what Boris did, and any reasons that he might offer for what he did. David, did you have anything to interject there before I get into how to fire someone for serious misconduct?
Yeah. Okay, look, I think, you know, you've covered, I think, most of it, so I might just sort of elaborate on a couple of things. I think, the company policy concept, do they do custom orders? Is there a process of approval for custom orders? Did he follow it, not follow it? I think that's key. It's actually, it's separate from the fact that it's poisonous. So, I think that's really understanding not just whether there was an occupational health and safety issue or whether he grew something he wasn't supposed to. There's also an understanding about whether the process that governed this was followed, not followed. And having no process, and let's say there's a convention within the company where people can just sort of randomly grow things that people asked for, that may then lend itself against the company in how they look at this. They're foxgloves. I don't know anything about foxgloves, but I know flowers take time to grow. These people are all qualified in horticulture, I would assume. So I guess from my perspective, one of the things that I would be asking is, how is it that this individual grew these flowers? To what state did they grow before they were found? How long does that mean they were sitting there? And he's level 2, he has some independence, but that doesn't mean that he's running the nursery. There is someone running that nursery. What were they doing, and at what point were they discovered? And was that a reasonable amount of time? Maybe they were fully grown and it was discovered, and that's not reasonable. Maybe they were just sprouting and it was discovered, in which case the discovery would constitute a reasonable time frame for discovery. Those are the questions that pop into my mind as soon as sort of I look at this particular circumstance. I don't want to just know what Boris did or didn't do. I want to understand what the people around him did and didn't do, because two things. It doesn't mean that Boris wouldn't necessarily be fired for it, but it also may mean that from my perspective, we might be handing out a few more formal warnings. Because there could be some lapses in process here, not just from Boris's behalf. And I just want to really double down on something Nicola sort of finished with, that the ability to respond. Everybody gets a chance to respond. It doesn't matter that he could be 1,000% in the wrong. It just doesn't matter. Everybody gets an opportunity to respond, and I think that's really important to drum home. Is that even if you're going to fire someone, before you give them the letter, you ask them, is there any reason why this would take place? Yeah, I think, what was the other thing that looking at? Oh, and then Nicola talks about how poisonous were these foxgloves. I would want to understand that as well, because that would then govern how much of an OH&S breach is it. Are they mildly poisonous? So it's really just the company, being extra safe, and therefore the risk to OH&S, generally speaking, was low. I don't imagine people, if you had to ingest it, I don't imagine people are randomly ripping flowers up in the nursery and having a munch as they're walking past. So, generally speaking, maybe it's actually very low risk. But maybe if you brush up against it with your skin, maybe then, the poison can get in. I don't know. I'm just putting out two potential scenarios that are very, very different, and therefore have very different OH&S outcomes.
Thanks, David. So the final I think this is the final consideration, is that DKMV terminated Boris's employment not because of misconduct, but because of poor performance. So David, did you want to talk us through some of the considerations on this one?
You broke up there a little bit, but
sorry.
Sorry, can you say that again?
Do you want to talk us through some of the considerations, given that they're terminating for poor performance rather than misconduct?
Yeah, right. So I think when it comes to poor performance, what's really important is setting up that is ensuring that you've completed an appropriate due process. So if they've given him one warning and terminated him, then he hasn't had the opportunity to improve his performance. So when you do terminate someone for poor performance, it's not just about pumping out 3 letters and then filling the dates in later. It is very much about providing that person a formal warning, and then also a path to improve. It doesn't mean you have to do it for them. It doesn't mean you have to lay out every step of improvement, but you do have to provide them notice of what they did wrong, and then you do have to provide them the direction that they need to travel. And so you're effectively terminating. The way I like to say people should think about it is that when you're terminating for poor performance, you're not really terminating them for that poor performance. You're terminating them for failing to improve. And whilst that is technically wrong because you are firing them for their poor performance, what it does do is it puts you in the right frame of mind in terms of how you follow that process. And so you're constantly providing that individual the feedback they need to take their own skills qualitatively or quantitatively in that right step or in that right direction. So in terms of the considerations for Boris here, I would be asking, was he provided all those warnings? Were those warnings, nice and explicit, providing him the frame that he needs to do different next time? And then in terms of the meeting itself, I think it's a bit. For me personally, I actually do a lot of these, unfortunately. And so for me, I have a bit of a set process and system. But what I would say to other people is, rehearse, know what you're going to say, even down to when you hand them the letter, where you don't. It is quite nerve-wracking for an individual firing someone, particularly for the first time. And a lot of people struggle with that concept. They are both anxious and fearful. They don't want to get something wrong. And at the same time, they understand that can be quite a confrontational situation. So rehearsal is important. Have someone there with you. Don't do a panel. I mean, it's awful when you see like 4 people get up to handle one of these meetings for one employee. That's a terrible situation. Don't make it a panel. You obviously want someone else there, but keep it to a small group of people, 2 or 3 people. Nicola talked about that support person is really key, that they have that opportunity for a support person. That's really important. And then just be prepared to get emotional. It may, and that's fine. It's a situation that is going to be emotional for many people. So when you're in that meeting, make sure you rehearse it. Another consideration that I find is that people come back and you go, oh no, that's wrong because of X, Y, and Z. You don't actually have to come up with something new. You can just say, no, you're wrong. This is the fact, this is what's real, and this is why you're being terminated. And
as long as you've considered it before, because you haven't given them that opportunity to respond, that's when you suddenly have to start thinking on your feet and responding. That's why that opportunity to respond early on is so important.
Absolutely. And look, it can surprise you. Like I said, I've been in a lot, so I've been in plenty that have just said, oh, okay, thanks, and then the meeting's over. So that happens as well. Don't look too surprised, and also don't try and continue the meeting like somehow something went wrong. So some people want it quick and over, and they're done and they're out, and others will want to argue till the cows come home. You want to let that process continue for a little while, but once you've given them the opportunity to have their say and they've said anything and they've started repeating, you are within your rights to now shut that conversation down. Yeah. Because you provide them opportunity. And what else would I say? I think the last point is stick to the facts. It sounds pretty obvious, but people sometimes get a little bit nervous, and they start trying to think of new things. Nothing in that meeting should be new. You should not be saying a single thing other than you're fired. You should be not saying a single thing that person doesn't already know. And so because they should have had forewarning. They should have seen that performance management before, so they should know that this is a potential outcome. But yes, some people will be surprised that the words come out of you now.
Yeah, and just one last thing is that I know both 44 Degrees and Melbourne HR can help employers with scripts or with rehearsal and practicing so that you know what to say if you're really, really struggling. On to the next one. So this is something that we've touched on earlier, and I'm conscious of the time, so I'll try and make things a little bit quicker. Performance managing and bullying will almost always be overlapped. It is extraordinarily common for someone to say that the performance management they're going through is bullying. The defense to bullying is reasonable management action. And if it's reasonable management action carried out in a reasonable manner, then it is not bullying at work. This is when you need to do all of the things that David and I have already discussed. Keep a level head. Don't get aggressive or unreasonable. Remember to be on your best behaviour, even if they're being on their worst behaviour. Making sure that, you know, all of the performance management is justified. There's facts, there's evidence of them underperforming, and then it's really clear how they can improve. Making sure that there's no, untoward comments or discriminatory comments while you're performance managing. And from a lawyer's perspective, I really want you to document things. Document your written warnings, document your verbal warnings, document your written warnings, keep examples of the bad conduct or the unimproved conduct, because that makes life so much easier in proving that the behaviour was reasonable management action as opposed to bullying itself. Did you have anything to add?
Yeah, sorry, just with the noting down of events and circumstances, sending yourself an email is always a good one. It timestamps it. It's a device you have readily available. If you keep the titles relatively unique and the same between all the notes, it means you can search them and have them pop up for you. Just in terms of notation, you don't need to have a leather-bound diary and write it all out. You can just send yourself email notes. It's a nice, good timestamp, or you can just update, your boss. Maybe they're like, oh, you can say, hey, we just wanted to give you an update on what happened. Another way of, killing two birds with one stone.
That's great evidence. So moving on to scenario 2.
All right.
Nicole's going to read it out for us again, poor thing.
So on the second floor, Felicia Ferguson has been working for DKMV and its parent company for almost 30 years. She was one of the first people to be employed when the business was founded and was also there when the children of the former GM purchased the business and registered a new company. Her employment goes so far back that she even visited the old GM's wife in the hospital when the current GM was born. Felicia has been doing the same work throughout her employment. Felicia is currently working full-time as the head of the marketing team and manages 5 people in the administration office. Before the COVID-19 lockdown, the business had a turnover of $10 million per annum. Once businesses were out of lockdown and able to start working, DKMV has not been able to generate more than $6 million. During various admin team and board meetings, it was concluded that the business was consistently failing to gain new leads and customers. It was also discussed that no one in the marketing team has met their KPIs since coming out of lockdown. Due to Felicia's tenure, her contract is old and out of date, and she has no KPIs to meet. She's also paid at the top salary bracket for an individual in her position. On the 12th of January 2022, DKMV decides to make Felicia and her team redundant. On the 15th of January 2022, Felicia was having a chat to one of the decision makers of the company and stated that the leads have been so bad that at this rate, I'm worried I'll be out of a job. In a state of panic, the person stated that, oh no, of course you won't. On the 18th of January 2022, Felicia was asked to attend a meeting whereby DKMV stated that they were making her and her entire team redundant, and the current GM is going to try and do virtual or digital marketing to himself to keep costs down. Felicia becomes very upset and starts swearing at the people attending the meeting. DKMV decides to change the termination to gross misconduct as a result of her behaviour. Following the meeting, TKMV in a heartfelt email to entire staff states, "We say bye to Felicia and her team today."
I think what we might do is we're just going to go, obviously we're a little bit behind time. We've been a bit more detailed in how we've gone with the first scenario. So I won't cover anything that we've covered before. With a particular situation, we're not really looking at an award circumstance. Obviously all people, everybody is covered by the National Employment Standards. But in this case, we have a common law contract. I think we can assume that if she's head of marketing, she's likely well above award rates. Considerations, does a contract reflect her current position? I think I'd be sort of more interested, in those termination clauses and those conduct clauses within her contract, whether conduct is within the contract or within company policies, and whether those company policies were up to date. And the other thing that I'd be looking at really is there a position description separate from the contract? I would be sort of seeking out those sort of details. These things can kind of be separated out a little bit. And so this is quite common, by the way, to have someone who's been in the company for 30 years and no one updates the contract. Yes, letter of variations are fine. But at some point you just have to sit there and go, well, we're up to number 3 or 4 of letter of variations. Let's freshen this contract up. And I think that's really, really key. Particularly when you have promotions. I'm always a big believer in a change in contracts. Nicola, you want to say something?
Yes, no, definitely. And please come and get your contracts updated, and you can also update someone's KPIs. It's not difficult to do when things are going well, and always better to get it done as soon as you can. Yeah,
absolutely. I mean, I think largely speaking, if it's in terms of how we generally do it at Melbourne HR, if their contract is staying the same, they're just getting a pay increase, then we make a letter of variation. For anything more than that, we change people's contracts.
So the second scenario is really talking about redundancy. The business is currently failing, and whether that provides enough context for redundancy. The business genuinely failing is a really good indication that it's a genuine redundancy, but it's not a slam dunk. The business might be failing, but at some point the marketing still needs to be done by someone. Is it legitimate that the GM is going to do the marketing as well as their other duties of a team of 5 people? Or is he really just going to hire someone as soon as Felicia and her team go away? Where are the roles? Where are the duties that they were doing? If they were not meeting their KPIs, were they at least meeting 50% of their KPIs? Doesn't really seem to make sense to be getting rid of 5 people and having a general manager who has a very large range of roles to be taking on all of that work, unless the business is really, really significantly downsizing. The other factors to consider is with redundancy, you need to often go through a consultation process, and you also need to consider whether appropriate notice was given. There is not much basis for involving poor performance when redundancy is in question. Redundancy should be about the role that is being done and that the role is no longer needed. And the role can no longer be needed because they don't have work to do, because of the pandemic, because we don't need someone spending this much time and money on marketing when no one is there to buy from our business. It needs to be about the role rather than have poor performance. So just having a look at those, I think we've touched on most of those considerations other than the swearing during the meeting. So swearing during a meeting is not usually a basis for serious misconduct. You need to have a little bit more, you need to have threats, you need to have people feel unsafe. You need to create that issue of safety rather than swearing. The reality is that in a lot of industries, in a lot of offices, swearing and yelling happens often enough that it is not of itself grounds for immediate summary dismissal. And so, in my view, without more about the swearing, say that she was being aggressive, or she was standing over people, or looking like she was going to punch someone or trying to punch someone, then you really shouldn't be trying to change that redundancy to serious misconduct.
Yeah, and also I think if this was a client of mine and they came to me after they'd attempted to change the method of termination, I would have a lot of queries, probably before I took them on as a client, about why this desire to change it to a termination. At the end of the day, a company's decisions should be utilitarian and not emotional, and therefore if the redundancy and the termination achieves the same outcome in the sense that the individual is no longer there. So what is it? Why is it the company desperately wanted to change? Because that might, again, the last question is, what were the hiring processes post redundancy? And a termination would make that hiring process easier if there was one. So to me, that would, trigger something in the back of my head where I'm like, okay, does this company have a plan to hire somebody or something, some capacity post this redundancy? Yeah.
So the final consideration is about termination letters and entitlements. Someone's last pay will often have to require payout of annual leave. Given how long Felicia's been there, long service leave seems to also be within that requirement. Just an email saying bye Felicia is not really professionally appropriate and can make someone more likely to make a legal claim, but it is not going to turn your legal claim on its head. You just need to make sure that you pay her all of her entitlements, preferably as soon as possible after the last day of her employment.
And the only thing I'd say on that is that these circumstances can be quite emotional for the people who are not part of those who are getting made redundant. So I think it's, the communication piece in a redundancy circumstance is very, very important. You need to make people feel safe in their roles post redundancy, and you need to make them feel like it's not going to happen to them. And generally speaking, if you're going to have rounds of redundancy, the preference is you condense those as much as you can. Once you sort of get to third and fourth rounds, everybody is looking for a new job, regardless of whether they're safe or not.
Yeah. Thanks, David. So I'm just conscious of time, and we have a couple of questions in the Everybody group chat. Rochelle has asked whether you can still hold someone to account to comply with an employee handbook, even if they haven't signed to say that they've accepted the employee handbook. David's on mute, so I'll kick off on that one. So effectively, yes, you can hold them to account to comply with the employee handbook. You just want to make sure that they have been given a copy and they have been directed that they need to comply with it and given a reasonable opportunity to read it and understand it. Generally, we like to, as lawyers, get someone to sign and say they've received it or they've accepted it. But that's just for documentation purposes, because we can say, aha, here's proof that you had it and you could read it and you knew you had to comply with it, but it is not actually required to get that signature.
So one of the other questions we have, I don't know if everyone can see it, is can you please touch on the matter of termination during probation, different scenarios, etc.
Yeah, I might jump in if that's okay. Look, with probation, it's very much different circumstance. This is, I guess, the opportunity for a company to see whether that individual fits the role. So in terms of terminating during probation, the company has, I guess, immunity to be taken to fair work outside of general protections. It's not framed like that. It's not an immunity, but the employee can't take...
Unfair dismissal doesn't apply when you're on probation.
Yeah.
So the only thing you have to worry about is discrimination, adverse action.
Yeah. And so, but I think what's really key is that, one, you do have to provide that employee some feedback. It's not the same as a normal performance management process. But if you sit there at month 5 and you just say, look, you know what, it's not working out, goodbye. and you provided them zero feedback at that time, then that isn't an appropriate process. I don't have the case for you, but someone did get busted for providing zero feedback and terminating someone on probation. It doesn't have to be a full performance improvement process. You literally just have had to provide them some feedback at some point. So the bar is still very, very low. But I think that's a really important process. And I think because of this, because you get so much protection as a company during probation, it's really key that you utilize that from a people and culture perspective. So you need to have a really clear understanding of what you expect. 6 months may not be enough time to get someone fully up to speed, depending on how junior they are. A more senior person, you would expect to get up to speed at a faster rate. But you would have an expectation. You need to have a clear vision in your head when you hire someone of what you expect them to achieve in terms of their abilities by that sort of 5-6 month mark. It's a good idea to just sit down with them at the 3 month mark and tell them how you think it's going. And then if it's not working out, you need to utilize that probation. There is no extending it. There's no, oh, I think they're coming good. 6 months is a good amount of time. Utilize it. If it's not working out for you, make a hiring decision. And sometimes it's better to move on from an employee. So I think that's probably the key thing. I don't think people utilize probation in the private sector as much as they really should.
Now, I am conscious of the time, however, this is the portion of the presentation that we are opening to questions. So if you have any questions, please feel free to ask them now. You're more than welcome to turn on your camera or your microphone and ask Nicola and David directly. Again, we are very much out of time. However, I think Nicola and David will give you some time to ask some questions. I think Peter has a question he would like to ask.
Thanks a lot. Just a quick question, just touching on Nicola's comment about general protections. My understanding is someone can still make a general protections claim if they're claiming adverse action consequent to termination during probation.
Yeah, so if you can still make an adverse action claim if you've been fired during a probation period. Yeah. But as I said, adverse action is about effectively discriminatory conduct. So as long as there's no evidence to suggest that they are being terminated during probation because they're exercising a workplace right or because one of those protected attributes, you're usually fine.
Thank you.
Yeah.
Does anyone else have any questions they would like to ask? Again, we will be recording, and this has been recorded, and will go on the 44 Degrees and Melbourne HR website. And if you have any questions, you can obviously email either one and we will answer your question to the best of our ability. However, this is your chance to ask your questions directly.
Carolyn asks, does the support person need to be a workmate? No, they don't. And sometimes it's actually better for them not to be a workmate. Sometimes having a friend or a family member that's completely divorced from the workplace can make things a lot easier. You just want to be careful if there's any confidential information that the support person knows that it's confidential and, complies by any confidentiality obligations.
Any other questions?
Any other questions? No?
Nothing's coming through. Well, we might as well end the meeting today. Thank you everyone for joining us today for our Law Week event of Steps Towards Fair and Lawful Termination. Again, if you have any questions, please send us an email. Otherwise, thank you for joining us.
Thank you so much.
Thank you, everyone.
Bye, everyone.
Thank you.